Christian Bryant. In a world full of squares, we're gonna keep things round. You feel me? Plus, you can't be boxed in with a big old circle on the logo. Anyway, here's what we got for y'all on tonight's show. Law is, and has always been, one of the least diverse professional fields in America. It's a field largely dominated by white professionals who make up nearly 80% of all legal occupations. Black Americans make up just over 10% of the field's workforce. Meanwhile, Asian Americans account for about 8%. And when you compare that to the diversity of the overall workforce, you see white and Asian Americans are well represented in law, but there just aren't enough black lawyers and judges out there. A lot of it comes down to the disparities in access to quality education, coupled with biased testing standards that add to a black-white score gap on standardized tests. Actual access to those tests, and higher education in general, also remains a privilege mostly available to higher income, majority white communities.
And then once people do go to law school, pass the bar, and join the very tiny fragment of people of color lawyers, there's still barriers upon barriers faced upon them with respect to advancement. Many people say, well, they're not qualified people. Well, they are qualified people. You're just not looking for them.
That's Nkechi Taifa, a human rights attorney based out of Washington, D.C., and author of the book Black Power, Black Lawyer. Taifa also stressed that at a time when the country has been reckoning with its treatment of Black Americans, especially within the justice system, it's worth looking at the people in power and examining how a lack of diversity in the judiciary plays a role in what many call a broken system.
There has been a sea change of opinion across the board in the aftermath of the murder of George Floyd, Breonna Taylor, and the so many countless others. I think it has made many people much, much more aware of what is actually going on in the system. And I think it really has brought to a fore that Black lives do in fact matter. They matter in the criminal justice system. They matter in the courts.
It's slow, but the trends are turning, with law seeing a little more interest from different ethnic groups in general, even though overall interest in law is still down since before the Great Recession. And the actual number of Black applicants is still decreasing, despite a small proportional increase in legal occupations. Although within that small pool of applicants, nearly twice as many Black women as Black men actually study law. Black women lawyers have in recent years also held prominent titles. Loretta Lynch became the first one to hold the title of U.S. Attorney General in 2015. In 2020, Vice President Kamala Harris, who was California's first woman of color Attorney General before becoming senator and making her way to the White House, became the first woman and first Black and South Asian American to represent that office. And now, President Joe Biden has vowed to appoint the country's first Black woman to the Supreme Court. Now, out of the 238 Black judges currently sitting on federal benches, less than a third are women. So his pool of potential nominees is small, but the significance of a Black woman on the bench of the highest court in the land would be huge. National correspondent Amber Strong takes a closer look at that significance and the court's history of firsts.
President Biden caused a bit of a stir among some groups when he made the announcement that he would nominate the first Black female Supreme Court justice. But a president nominating the first in any category isn't exactly new, and neither is the backlash. While the president has taken some flack for announcing his plans to pick a certain type of nominee,
we are putting together a list of a group of African American women who are qualified and have the experience to be in the court.
He wasn't the first.
During my campaign for the presidency, I made a commitment that one of my first appointments to the Supreme Court vacancy would be the most qualified woman that I could possibly find.
That woman was Sandra Day O'Connor. Historians say when you're the first,
Judge Sonia Sotomayor,
scrutiny will follow. Take Louis Brandeis, the first Jewish Supreme Court justice.
Nobody was standing up and saying, oh my God, we can't have a Jew on the Supreme Court. It was more subtle and whispered.
Instead, law professor and Supreme Court author Stephen Warr Mills says anti-Semitism toward Brandeis was often labeled as a dislike of his legal work or his role as an activist, a theme that would continue.
I believe it's the right thing to do, the right time to do it, the right man in the right place.
The appointment of acclaimed lawyer Thurgood Marshall was years in the making.
I'm certain that there's no possible reason that I could have to not adequately represent this government, which is, after all, my government.
That didn't stop the backlash from those who believed him to be too closely tied to the civil rights movement.
The racism came right out on the table, full out there. During his confirmation hearing in the Senate Judiciary Committee, a senator asked him if he hated white people.
It was something he'd faced before. His appointment to the U.S. Court of Appeals by President John F. Kennedy years earlier was also met with rejection from Southern Democrats and voters who sent letters to Kennedy questioning his Christianity over Marshall's nomination. While President Reagan's nomination of O'Connor was much less contentious than Marshall or Brandeis, President Reagan also faced backlash, writing in his diary, "Already the flack is starting from my own supporters." The pushback was from the growing evangelical right, who feared O'Connor would be an advocate for abortion rights. Still, overall, Reagan was largely applauded for the move. In the 233 years of the court and the 115 justices, there have been 5 women, no justices of Asian or Native American descent, and the first Italian-American, Antonin Scalia, wasn't confirmed until 1986. Warmill says regardless of the outcome or how beloved a nominee may become, history shows backlash is inevitable. Now, Americans are torn about the president's decision to nominate the first African-American female Supreme Court justice, with about 51% in a poll saying that they support the decision. But a separate poll shows 55% saying it's not important. Back to you.
All right, many thanks for that, Amber. Now we're going to take a deeper look at representation in the cases that reach the Supreme Court, specifically cases that involve Native Americans and their land rights. Outgoing Justice Stephen Breyer's legacy and his history on Indian law cases is worth examining as President Biden prepares to nominate his replacement. National correspondent Allison Herrera takes a look at Justice Breyer's record and how the Supreme Court overall has often landed at odds with Indian law.
He advised the Cherokees to file a lawsuit.
There's a C-SPAN video. Yes, a C-SPAN video of Justice Stephen Breyer speaking in front of the Supreme Court Historical Society in the early 2000s about the importance of cases involving the Cherokee Nation at the Supreme Court in the 1830s. One of those cases was largely responsible for the Trail of Tears.
United States shall guarantee to the Cherokee Nation all their lands not hereby ceded. The Constitution itself made, quote, treaties, quote, the supreme law of the land, and the Supreme Court had made clear 20 years before in the Yazoo Lands case, Fletcher versus Peck, that it would strike down state laws that violated constitutional provisions.
Breyer took an interest in these cases to explain the limit of the nation's highest court. Cherokee cases for Justice Breyer are an example of how early in the Supreme Court's history, its ability to enforce American law were put to the test.
I really appreciated that he brought up the Cherokee cases because those cases were part of a string of cases at the Supreme Court in the 1830s that could have started the Civil War.
That's Matthew Fletcher. He's a foundation professor of law at Michigan State University College of Law and director of the Indigenous Law and Policy Center. Fletcher says that Breyer's legacy and his history on Indian law cases is worth examining as Biden prepares to nominate a replacement for him in the coming weeks. Fletcher says Breyer was, quote, no tribal sovereignty warrior a la Sonia Sotomayor, but he was no Indian fighter either, end quote. Meaning his record on voting in favor of Indian rights at the nation's highest court was, well, spotty. The first case, shortly after being nominated and confirmed in 1994, was Oklahoma Tax Commission versus the Chickasaw Nation. He voted in favor of the Chickasaw Nation.
Bob Woodward wrote his book in the 1970s called The Brethren, about the backstories of Supreme Court cases in the 1970s. He asked questions like, what are the worst cases that you could possibly have? The ones that the justices hated the most. They said tax cases and they said Indian cases.
The central question in the case, are tribal citizens exempt from state taxes, particularly when tribal citizens work for a tribal business on tribal land? One of the most controversial Indian law cases to come before the Supreme Court was Adoptive Couple versus Baby Girl in 2013. It involved the Indian Child Welfare Act. Breyer, this time, sided against tribal interests in the case. Fletcher said the decision was an embarrassment to the court.
They left out facts that are plainly relevant to the for the tribe's perspectives. They just got the law wrong, and they wanted the non-Indian couple to win the case. And it was a 5-4 case, very hotly contested, and Justice Breyer voted for the white couple.
Since 2014, the Supreme Court has sided with tribal interests. Fletcher says it started with a case called United States versus Lara, which asked the question, does the Indian Civil Rights Act of 1968 give Indian tribes the right to prosecute non-citizens?
Maybe at the time it was sort of a non-important case, but if Congress is going to, for example, amend VAWA to allow for tribes to prosecute non-Indians in certain contexts, which it partially already has, Lara is the foundational case for that.
One of the biggest issues is that many law schools and judges on the federal bench don't have an understanding of Indian law.
Those faculties don't have any interest or care in Indian law. In fact, many of them are kind of afraid of it because they don't want to get it wrong. They also don't want to learn it.
Recently, there has been another shift on the Supreme Court with the appointment of Justice Neil Gorsuch, who wrote the opinion in McGirt versus Oklahoma, and Justice Sonia Sotomayor, who by all accounts takes Indian law very seriously. The question is, will Biden's nominee have that background too? For Newsy, I'm Allison Herrera.